So good morning, everybody. Welcome to the joint sponsored program for this month, from both ACE and the Maine Technology Institute. I just want to introduce ACE a little bit. ACE is a nonprofit association of professional consultants and coaches. We provide an array of services and benefits to our members. We help people develop their consultancy professionally. We help promote their business, and we help them to build their network and hopefully collaborate together on many projects. I also wanted to briefly announce that our next program is November 18th, and it's around a workforce issue, retention strategies in the new paradigm. And Francis Eberly, who's on the call, is one of the presenters of that session. So we hope that that'll be a great end to our workforce series. And I want to give a brief teaser to our upcoming program in January. We're going to be doing a Consultants Academy. This will be a live event at the Cumberland Club in Portland. And I think it'll be a great opportunity for new and even established consultants to refine their business and really help them to see what's going on in the world and kind of look at their business in a different way. So I hope you can join us for that. Wanted to talk a little bit about the event today, Crafting Comprehensive Consulting Agreements. This event really came about based on a program we did in June where the Maine Entrepreneurial Resource Corps was introduced to us by Matt Hoffner and Emily Braley from MTI. And it became clear at that there was a need for people to understand MTI's role in the market process, and also how we should be thinking about this for these smaller businesses in terms of the needs for crafting comprehensive consulting agreements, and what is an SOP, or SOW, statement of work, and how to do deliverables and measurables. So that was the emphasis for this program. That's really all I had to say this morning. I want to introduce Joe Migliaccio from the Maine Technology Institute. I think Joe was employee 1 up there, so he knows a lot about what's going on. And take it away, Joe.
Okay, here we go. Let's see. That's not the screen I wanted. One sec. There we go. You guys all see that now? Yep, good. Well, first, welcome. And today, thank you. I'm Joe Migliaccio, the Director of Portfolio Advancement at MTI. I think I was the second employee. The first and the others, some of you may have known our first president, Janet Yancey Rona, who was also an applicant. We've had Betsy Beeman, who's now CEO, Bob Martin, and now Brian Whitney is the president of MTI. The president of MTI is a state employee that oversees us as private sector individuals working in the venture development organization that is a nonprofit. So yes, we don't solicit, but you could conceivably make donations to MTI. We are in Maine the premier technology-based economic development nonprofit, and we focus specifically on 7 technology areas that are defined in the state's economic development plan. So we're excited to co-sponsor this event today with the association, because the topics you'll discuss today are just a small tip of the iceberg on one of the most common drags and death blows for many innovation-driven startups. That is the inability of the founder and startup teams to use language, planning, and communication tools in a way that effectively conveys the problem, solution, vision for the journey ahead in a way that connects with the investor or funder. For today, I will surrogate and say, as you apply to MTI, okay? So today's session's timely for MTI And it's not an accident, as Terry says, that it comes so soon after MTI recently launched its Merck grant program, the Maine Entrepreneurial Resource Corps. That program is designed with two core focus areas, goals. One, to speed identification of quality professional services for innovation-driven enterprises. And two, to reduce the financial risk for consultants working with typically might be thinly capitalized companies. So that's how it relates. That's Merck, and why this is important to Merck is because scopes of work and context are part of the application process that Emily and Matt shared with you. And their presentation on Merck itself is listed on the ACE website. So you can go back and look at that. But there's also a third reason that this is important to MTI. It's because that single program, Merck aside, solid measurable scopes of work and explanations of such are required in virtually every MTI application and are a critical focus of our due diligence. Obviously, that's for any funder or pitch. My colleague Tom Kittredge is going to get into discussion and deeper into scopes of work and dialogue. So I just wanted to mention that we were going to share some war stories and bad experiences, but instead I decided let's give you an analogy to kick off today and set some goals, which is, as consulting and business professionals, you know that the best outcome for growing and sustaining a business or your practice is to successfully deliver on goals, budget, timelines in such a way that the client becomes the enthusiastic promoter for reference for future clients. We hope this session and your membership in ACE or utilization of ACE services and networks plays some part in that success. So before ending my introduction, I just wanted to set a little bit of the tone and understanding where everyone lives here. So the analogy I'm going to use is, as we work with startups in this, is a through hiking analogy. So many of you have probably hiked, some of you have done parts or maybe all of the Appalachian Trail or other through hikes. And the analogy today is goal setting. So if this were a startup journey, were a hike, through hike, you'd be setting goals. The goal in this case might be complete the Appalachian Trail and summit at Katahdin. To start with that, you got to do self-assessments. You got to determine whether you're a short, one or two legs at a time person, or if you're going to do it all at once. You'll need to do things like assess weeks, times, months. How long do we have, or years to do this? You'll be looking at things like the team. Do you need to hire trail guides, recruit trail buddies, or are you going to do this solo? But it all requires setting goals and determining responsibilities, just like you'll do in the scope of work. You'll need to talk about and think about things like provisioning, food, fluids, shelter, gear in a startup that can all be boiled down to things like money and infrastructure. There'll be times in the journey that'll be fatigue and despair, physical wear down, mindset wear down, and oftentimes this affects decision making. So it might be easy to go chase, a small grant because the instant gratification of getting that is important, but maybe that's not the right thing at this time. So what I want to say is always understand, at least when working with MTI, this money is precious. The startup money is precious. There are limits to how many times you can come back to the well as a company before you level up. So please work with clients. My suggestion is to make sure that the scope of works that they're submitting to us, that you're involved in, are clear and contextual and are the best and highest uses of that money at the time. And it's risky. You'll have a lot of change and externalities will affect. If you fall behind on your through hike by a few weeks and winter starts to set in and you're not prepared, that's similar to maybe the competition getting ahead of you. So time and speed is always money important. You're going to have people that drop out, and but the important thing is every day you're going to start off with an assessment of where you are, and every night you're going to end up assessing where you're going the next day and adjusting. So with that, I know there's a few design and lean thinking people in the audience. All of that planning and for the through hike or where this exit's going to go with the company or growth involves all of this same design thinking, lean startup methodologies, a lot of failure assessment, learning from failure, and rebooting assumptions. So every one of the contractors and companies that would be applying somewhere are typically in this ideate and discovery and trying experiments stage and learning. And I always like this. This is from B-plan experts, but I'll send this slide deck around, but I always like this because if you look at it, you'll see that if this were the trail or the startup journey, at different points in time, you're going to have need for external resources, knowledge, and scopes of work, and the contracting that you'll discuss today are all critical parts of making sure goals are aligned and we're focusing on ultimately the finish line. Anywhere in this journey, you should be able to ask the company or read the pitch and understand where we're ultimately going. But what gets fuzzy a little bit is the need to iterate and constantly assess, essentially apply the scientific method to this. And ultimately at the end, you're gonna get to the summit. I'm gonna share this story in the deck. I've got one more that I think is pretty good. And if you read Kate's story and one other that equates the startup journey to hiking and planning, I think it'll help you when you're working with clients. Please, a reflection of the quality of work going in is also going to set up for excellent results and expectations at the end. So oftentimes the last thing I'll say is when I work with consultants and companies that are trying to come together on something, the best consultants I've seen work this are the ones that push back on the company. They ask things like, where are we? Where are we going? Because if they're not aware of that, you may set up a scope of work and do a project. At the end, the results may not even be relevant anymore. And I think that'll be something that, reflects. So with that, I will kick it off and hand it over to Carrie. Any questions on any of this so far? All right. Look forward to seeing some of you in workshops later on, and thank you very much.
Okay, so here we go. I am Carrie Yardley. I'm a member of ACE. I'm currently on its board, and I'm going to be presenting on legal drafting tools and tricks. But as Tom Kittredge and I talked about it, we wanted to do a little bit of setup first. Tom is a senior investment officer at MTI, and he works with innovators at all stages of development, all stages of their investment processes, but he is quite devoted to the community, entrepreneurial community. He is a lead mentor for the Maine Center for Entrepreneurs, and he was he's on the committee for Startup Maine. So let me give you the tee up as to what we're going to be doing here today. We are going to offer two perspectives on scopes of work. One from the grantor or MTI perspective, and Tom will demonstrate what MTI is looking for in a scope of work on an MTI application. And obviously with the MERC program, consultant scope of work is going to be key. The other thing you should know is that as part of your project documentation package, you're going to have to submit the legal agreement between the consultant and the client. And that's, of course, where I step in, and I'll be talking about scopes of work and what I spot for, how I fix them, how I draft them. And then I'll be doing a somewhat briefer segment on legal terms that I think you need to look out for. So without further ado, I'm going to pass it over to Tom. And I'll stop sharing my screen.
Great. Thanks so much, Carrie. I appreciate that. It's good to be here all. Thanks so much for having me. Let me see if I can share my screen now. Let's see.
You hovering over the bottom? Yeah.
Yep, I think I have. Is that on there?
It is.
Fantastic. And that's whole screen?
Yep. You are side by side on my monitor.
Yeah, so we've got MTI scope of work.
And then seeing my face for a little bit, I hope. So good morning, everyone. My name is Tom Kittredge. As Carrie mentioned, I'm a senior investment officer at MTI, and I'm very excited to be here to talk to you all about scopes of work, which is a subject that's become very near and dear to my heart in my time at MTI. So I've been at MTI probably for close to 3 years now, and during that time, I've reviewed literally hundreds of scopes of work. From all of MTI's 7 different technology sectors, from businesses of all different sizes, with different goals, different levels of sophistication, objectives. These range from grant applications for $10,000 to, a loan application for $500,000. Yet regardless of the size of the request or the proposal, one of the things I found is that the scope of work is one of the most vital documents that is part of the project. And in my experience, a project scope of work is one of the most critical determinants of whether a project will succeed or fail. That might sound like a bit of an exaggeration, but in all sincerity, when MTI does a post-mortem of failed projects, one of the most common issues that we see is that the scope of work did not set the applicant up for success, or it created confusion or a lack of shared understanding between team members, or had outcomes that were non-specific or vague. So as an investment officer at MTI, one of the things I do on a pretty much daily basis is work with potential applicants to ensure that they are submitting strong scopes of work as part of their funding proposal. So I'm going to share a little bit about what I'm looking for in a good scope of work. But first, I just wanted to talk a little bit more about why a good scope of work is so important. So what are some of the key elements of a strong scope of work, and why is it so important? So first, a good scope of work ensures that all parties are on the same page. And by parties, this might mean external consultants, but it also could mean team members, investors, the founding team, contractors. But by having a strong scope of work that's clear and concise and really captures the project, you're setting yourself up for success from the get-go. Along those lines, it helps reduce the risk of miscommunication by having specificity, by having clarity as part of the scope of work. You greatly reduce the risk that team members are kind of working, for different goals or different outcomes. It serves as a written reference in case of disagreement. So unfortunately, in my time at MTI, and I'm sure Joe's had the same experience, I've seen a number of cases where applicants hired contractors or consultants, and then were disappointed with the outcome of that, of that hiring decision. And often it was not that the consultants or contractors didn't provide quality work, but rather that the work they provided was different than what the applicant had been hoping for. And often that's because there's a misunderstanding or miscommunication around what the project goals and deliverables were going to be. And again, that's where a strong scope of work can really come in and reduce the risk of disagreement down the line. It creates a checklist for key activities. So by having clear deliverables and clear outcomes, as the project progresses, you're able to check things off and really kind of keep track of where the project is going, what needs to still be accomplished, and what the desired outcomes are. And then lastly, it just encourages proactive visioning for the overall project. So the act of putting together a scope of work is an exercise in kind of visioning what the project is going to look like, and it helps from the outset to start writing down what are the projected timelines, what are the outcomes that we're looking to see. So I found that is one of the most beneficial components of a scope of work, is that exercise and kind of visioning the overall project. So this is MTI's standard scope of work template. So Joe and Carrie both already touched on this, but I just wanted to reemphasize. So MERC is a program run by MTI, but it's slightly different than MTI's core funding. So this is the scope of work template for MTI's core funding. But for the MERC program, there's a slightly different scope of work approach that Carrie will be describing more and that you'll be looking at during the workshops. But this is the scope of work that I and Joe kind of work with on a daily basis. And you can see it describes what are the key activities, what are the measurable deliverables associated with each of those activities, and then kind of what's the project timeline associated with each of those activities. And I'm going to go a little more in depth, but just to kind of provide an overview of what the template would look like for an MTI application. So in terms of kind of what MTI is looking for when we consider a scope of work, there's a few different key elements. The first is a clear description of the project's key activities. So what is the project seeking to achieve? For example, is it working towards a prototype, or is it filing a patent, or is it conducting market research or customer discovery? Those might all be, key activities that are associated with an MTI project. Second, what is the timeline for each activity? So, if the goal is to file for a patent, what is the projected amount of time that's going to take? Or if it's product development, what's the expected timeline of that? Third, and this is probably the most crucial one in my mind, is measurable specific deliverables for each activity. So quantifiable ways to determine whether or not the activity has been completed, and to really specifically call out what you're looking to achieve with each of the key activities. And then lastly, a clear use of funds aligned with the project's goals. So for any budget that's submitted to MTI, we want to see that it clearly aligns with the project goals and the desired outcomes. So, if a proposed scope of work was focused on product development, but the budget includes $10,000 for a marketing consultant, there's a bit of a discrepancy there. And so, MTI is really looking to see that there's clear alignment between the budget and the scope of work form. So just a little bit about some of the common shortcomings of proposed scopes of work that we see. One is just that the key activities are either vague or jumbled together. So because we're looking to see very clear deliverables associated with each activity and timeline, we really encourage applicants to break down key activities into very kind of clear sections. So rather than putting product development and marketing and customer discovery all together as one big lumped activity, we encourage our applicants to break them down very, very clearly. The second is that the timeline is unrealistic or lacking in specificity. An example of that would be, we frequently see scopes of work where the timeline is listed as going from Q2 to Q4, which is fairly vague. That's a 3-month span on each side. So we really encourage applicants to be very specific in their dates, with the understanding that sometimes throughout the course of a project that might evolve and change a bit. The third, and again, this is in my mind the most crucial, is that the deliverables are not measurable or are subject to interpretation. So going back to the example of customer discovery, if a deliverable is conduct customer discovery to assess interest in our product, what does that really mean? That could mean a casual chat with 10 of your close friends about the idea, or it could mean a rigorous outreach campaign to 200 customers representing specific customer segments and collecting really specific feedback. So, we're really looking to see some specificity about how you're looking to achieve the key activity and how, again, that we're going to be able to track at the end of it that it was successful. And then lastly, like I said, that the budget is not aligned with the scope of work. So there's a budget proposed and it doesn't clearly link to the goals and outcomes desired from the scope of work. So I wanted to show a kind of a sample scope of work based on a couple that I've been working on recently. And this is one that I consider to be fairly strong. It's not perfect, but I think there's a lot of elements here that kind of capture what we're looking to see. As you'll see, it's a kind of fictitious company named Tom Kittredge Inc., which does not exist yet. But yeah, so a few things that I liked about this scope of work. So, this key activity is focused on developing a consumer marketing strategy for Tom Kittredge Inc. And, it has measurable deliverables, one focused on developing a consumer marketing strategy, and the other on developing brand guidelines and style guide, and the last on conducting a user experience assessment of the website. So one of the things I like about this key activity is that it's very specific. So it goes into detail about what each of the elements, for example, in the first deliverable, it speaks specifically that, allocation of resources across digital, creative, and media campaigns, site and search engine optimization, and then a clear deliverable that it's a marketing strategy guide highlighting the key messages. And the same is true for the later two deliverables, that it's very specific. This hypothetical key activity is focused on user experience design changes to support user growth. And one of the things I really like about this is that it's measurable. So for example, under increased member activation rate from paid digital campaigns from 10% to 20%, that's a specific measurable outcome that we can track and confirm whether or not it was correct or achievable at the end of the project. And it's achievable. It's a realistic goal. They're not saying increase member activation rate from paid digital campaigns from 10% to 100%. It's a realistic, achievable goal that could be accomplished in the course of the project. And then one more kind of hypothetical key activity. So this one is run a paid digital marketing to increase user growth. So, one of the things I like about this one is it's relevant. So the activity is run a paid digital marketing campaign to increase user growth. And then the deliverables from this are relevant to the intended key activity. So, aiming to reach 20 million users by December 30, 2022. That's very relevant to the key activity. And same with achieving better than a $3 cost per acquisition. And then it's time bound. So it's the timeline is specific. It's called out both in the project timeline, but also in the deliverable itself. The goal is by the end of December 2022 to achieve those numbers. So those are the examples I wanted to share and a little bit of an overview of what MTI is looking for in a scope of work. This is an overview of what that scope of work would look like put all together. And again, this is kind of a hypothetical scope of work, but I think it's fairly indicative of what MTI is looking to see in one of our applications. So I wanted to take a moment to pause and see if there's any questions on that. And if not, I will hand it back over to Carrie.
Tom, this is Francis.
Yeah, hey, Francis.
Hi. I just had a question, and it may be that I couldn't read your last slide as carefully or quickly as I could.
Yeah,
but in the examples you gave, some of them weren't that specific in terms of the activities. So, for example, I think there was one. Yeah, we'll do this one. We'll strive to achieve better than $3 a cost per acquisition. So, what exactly would the company and consultant be doing? So that could be like the goal, and then there would be activity. So you don't go to that level, or you prefer it if we did. Does that make sense?
To an extent. So you're talking specifically about that second deliverable related to the key activity, or the fact that run a paid digital marketing campaign isn't that specific.
Yeah, more generally that there are no activities, develop a team that's going to focus here and then, send out whatever information, that kind of stuff.
Yeah, and it's interesting. I mean, I get a couple thoughts on that. One is, I agree with you that I think this second deliverable could be even more specific and could go into greater depth in terms of talking about, you're saying we will strive to achieve better than $3 cost per acquisition, but it would be helpful to understand, okay, how are you striving to achieve that? What is the intent? With that said, I think from an MTI perspective, the key thing here is that we're able to kind of track that at the end, whether or not it was achieved.
Right.
So they're saying that their desired outcome is, better than $3 cost per acquisition. That's something tangible that we can track at the end. With that said, I think that in the course of an MTI application, would definitely want to understand how do you plan to go about doing that. So I think you're right that this could be even more specific, and that would make this even stronger if it talked about kind of how they're going to go about achieving that.
Yeah.
Well, I was just thinking this through. So, because sometimes if they don't achieve it, you may not know why.
Yes.
Right.
Yeah, and that's part of the process we often do at the end of a project is try to understand. It's not uncommon for applicants to not be able to achieve every single deliverable, but we certainly try to understand why you weren't able to achieve it, and often it might be that the scope of work was not well defined, and as a result there wasn't a strong plan on how to reach that deliverable.
So
Carrie, did you have a
Francis,
comment?
yeah, Francis, I'll be dealing with that. And what you're getting at is kind of the heart of what the difference is in an application to MTI for a scope of work and what you're going to want in the ultimate legal document.
Yep.
Yeah, great. In some ways it's protecting the consultant too, because
right.
This would be on the hook for everything.
Yeah. The other thing that I would say, Francis, is that sometimes you don't really know what the steps are until you're deep in it. So I like to build in a scheduling meeting, where you develop the plan to my scope of work. So good question though. Excellent question.
Yeah, Carrie, it's Barry. I was going to ask that question too about in terms of there's a project timeline, but then you would want to, I would think, build in a certain times, that timeline I think was November through April theoretically, but you'd want to measure your progress along the way, correct?
Exactly. But there may not be room for it in the application, which is why you should not assume that your application scope of work is exactly the same as your contract scope of work.
Yeah, and just to reemphasize that point, primarily what I was talking about is what an MTI scope of work looks like for an application to MTI, and we're really, our biggest concern is the outcome. But I think in the context of what Carrie is going to talk to, I think the scopes of work that she's going to describe are also quite focused on process. If that's right, Carrie, is that true?
Yes. Lawyers are obsessed with process.
Yeah.
It's what we do.
So Carrie, I'll hand it back over to you unless anybody
Great.
else has any questions from the MTI side of things.
Great. All right. So I share screen. And I have this. Share it. And I am sharing, and now we're going to go into the slideshow mode here. Good morning, everybody. I'm going to start with an apology. I usually don't, but because we are dealing with text, this is going to be a text-heavy presentation. I tried to figure out cute little dancing animations that would help us, and I ultimately decided, no, you need to know what my world looks like, so that's what we're going to do. I am going to show you how I edit and draft professional scopes of work for service agreements. I'll give you some suggestions on what you should include in a scope of work. Donna, that will go to your question in the chat. Some of the tools and strategies I use. In fact, if you look at one of the handouts for the participants, you'll find a tool list in the workshop materials of what my toolbox consists of. I'm going to comment on how you might want to approach a MERC project in terms of achievability, keeping in mind that they have a 3-month duration. And finally, I'm going to move on to the legal terms. Tom referred to it as, a good reference to look back on in case there's a disagreement. I call it what the parties agreed to while they are still getting along. But basically, what Tom said is correct. You need some mechanism for dealing with unexpected circumstances. So moving on. This is what I consider to be the relative proportionate importance in a consulting agreement between scopes of work and the legal framework. I cannot emphasize to you enough how important a scope of work is. I'm going to tell you a brief story. It is a real story. A client came to me with a services agreement. I think it had been downloaded from the internet. And the scope of work was incorporated. It was on an exhibit and incorporated by reference, but it was utterly blank. And I said, well, what are you doing? And he said, well, we'll fill in those details later. And I went, okay. He said, but what I really want to know is this safe to sign? And I said, knock yourself out. It's not going to hurt you to sign a meaningless document. Because without the scope of work, there literally is no contract. A contract is an exchange of promises on essential terms, and the essential terms are the who, what, when, where, why, and how much is being exchanged. And if you don't have the essential terms filled out, there is no contract. It doesn't exist. The business terms really are the contract. And I would go so far as to say, if you have written down your essential terms, the business terms, and everybody signs off, you have a contract, even without the legal terms. Okay, that's an important concept, and I'm going to give it a minute to sink in while I change slides here. So we're going to talk about the scope of work first. That'll be about 75% of the presentation, and the legal terms will be much less. Tom alluded to it, that as you can guess, we've been talking a lot. But when I have a 20-year background in litigation, and a lot of it was commercial litigation. And I can honestly tell you that almost every contract that went to litigation was a dispute over scope, not the legal terms. So I had great fun for 20 years picking apart scopes of work. Then my career shifted, and I do transactional work, which was quite humbling because it is much harder to actually draft it right than it is to pick it apart. So the SMART analysis should be familiar to you all. It's used in project management, and about in 2016, I recognized a scope of work is essentially defining a project. I don't know why it took me that long to figure it out. So here we are. That's how you spell it. Let's talk about specificity. You should write in English, all right? You should not write in jargon. And you should, as you would on an application, break the project down into discrete tasks, which you identify in your scope. Now, when I say write in English, I mean English versus jargon. You're not going to be able to avoid using technical terms because you provide technical assistance, and that's fine. However, when I talk about jargon, this is what I mean. That actually crossed my desk. And from this, I can't even tell what discipline the writer is in. I don't know what the facets are of the alleged approach. I don't know how they're going to gather the possible risk in timing. I don't even know what possible project risk in timing is. So, if you think you know how to draft a scope of work, you're probably much better than this guy, but I have seen a lot of bad scopes of work over the years. So Tom and I collaborated on a how-to article in Main Biz, which is in your materials, by the way. And he basically lays out what MTI is looking for. But this is the example we used. We went from a very vague scope of work to this one. I will tell you, this could be more specific. But if you've got a relatively small project, even in a contract, I would probably sign off on this. There's enough there for people to know what's going on. And the thing I would say to you is that the language is reasonably excessive, even though there are some technical concepts such as target customer personas, in-person interviews, and it's all directed towards customer discovery. So one of the things I will do, it's greatly helped by breaking it into steps, but sometimes once the technical terms get kind of heavy, this is what I do. I use a glossary. All right. Honestly, I pulled all of these off of Google. So if you don't want to tell your consultant you don't understand what these things are, go to Dr. Google and Dr. Google will tell you. But I think it's honestly better to have it in the agreement itself. So as I said, the fact that this is broken down into discrete tasks is good. But what it doesn't address is what is not done. And I believe that, so this is, sorry, I got a little ahead of myself. If you wanted to make the example more specific, you might include, as Francis suggested, the qualities of the customers that you are, or customer personas that you're looking to identify. So the client will know that when they receive the sheet describing the target customers, they will know what details to expect. All right, so moving on to exclusions, my personal must do for a couple of reasons. It's an underutilized, completely underutilized technique that could be in virtually every consulting agreement. I'm going to give an example of a web design contract I reviewed, and it was the typical, we're going to create the architecture, et cetera, et cetera, et cetera. But it didn't anywhere say that the client was responsible for content. And the client, if you're like me, starting a new website, I was expecting turnkey. So it makes a lot of sense to say, hey, look, I'm doing the coding, I'm building the architecture, it will be what you want. What you produce to me, I will slot into the architecture, but I'm not even sure I'm using the right terms, by the way. But that the stuff is what you need to provide. If you can't do it in-house, I have people I work with all the time and I can make some introductions. So that would be a fairly significant omission in many consulting agreements. The other thing I would say to you is each of you has experienced that, where the client is surprised that something isn't included in the job. And I encourage people to maintain a life list of the things you need to continue to add to your contract exclusions. I hit one that I never expected. I was drafting a consulting agreement, and The client wanted to use a very particular proposal generating software, which was a bear to deal with in editing, because it was basically, it always converted to Adobe. You then had to copy the text out of Adobe. Fortunately, it did go into Word fairly smoothly. Make your corrections and send that file back for somebody else to include in the document itself. And I would say, it ate up hours. And so I say, I produce product in Word, Excel, and PowerPoint, and nothing else. Any other software, you would be responsible for that. But the key point is maintain that life list. Every time your client is surprised, write it down. Now, the other thing I encourage people to do is put in some assumptions concerning the necessary conditions, and sometimes they can get pretty specific. If you need access to a computer system or a network, from midnight to 3 o'clock every morning, say so. Okay. If you need the building to be shut down for a 3-day period, say so. If it has to be kept to a certain temperature, say so. So the other thing I would encourage people to do is actually set a response time for answers to questions. Sometimes these provisions can get pretty heavy-handed. In other words, if you don't make your deadline, we're moving forward and assuming you're approving. It's a heck of a way to do business, but sometimes having it and being able to waive it gets you part of the way. But in any event, timely answers to questions and receipt of information can be very, very important for keeping a project on track. And Donna, I think this is what you had put into the chat. The other thing, and this is something I had thought about over the years, it's used a lot in construction contracts and architectural contracts, is that it's to ask the client to designate a point person who has adequate authority and expertise to work you through the job. This is the person you call when you find that a question hasn't been answered for 10 days. And it's been, somebody else in the organization is responsible. This is the person who needs to be able to say, hey, this is really important to our company. When can I expect it? And what can I tell the consultant? So Joe had brought this up when we were talking about this program, and the idea of having a project manager on the project might be key. If you have to hire the outside project manager, that's something you should seriously consider. Many consultants come with project management experience in their discipline, so you don't necessarily have to have somebody who is on your team, within your company, who knows has the project management certification, but you do have somebody who knows enough to talk to the consultant. Now, on client obligations, I include them in my scope of work, period. Or at least number 2 and number 3. Number 2 should come as no surprise. Clients, your first obligation is reviewing and approving the scope of work. And when I say that, I mean you need to read it, you need to understand it, and if you don't understand, you need to ask questions. A lot of questions. And ideally, you will start to revise the scope of work to get a little bit more specific. So if in our previous example, I were looking at that scope of work and I would, and I didn't know what a target persona was, I might ask, what makes up a target persona? And that might generate the language I suggested, discussing the elements of a target persona. So the idea of documenting that kind of thing, as long as it's accurate, can be a very valuable lesson to the consultant in future drafting as well. You know, so, words they use all the time may not be penetrable to a client. Now, obviously, payment is important. Everybody knows that consultants have a fee. There are grants, by the way, for paying for it. And so I'm going to talk about that. And I think this is what Tom was talking about when you tie, when you come to tie your deliverables or your phases to payment. So they should line up. In most consulting agreements, there are progress payments upon termination of phases. There are other mechanisms, you know, hourly, beloved of all lawyers. But there are also sometimes, you know, you'll pay a certain amount a month and justify it at the end, you know. But basically, I think you're going to find in a standard consulting agreement, you're going to have progress payments based on actual progress. So you need to line it up. So I have one more comment on cooperation. This really clients comes down to resource allocation. Very common misunderstanding, particularly in newer businesses, is that a consultant contract is a turnkey project that you can walk away and let the consultant work its magic. Most consultants aren't elves. We need a little help. And so you need to understand the true time commitment it is to bring a technical project over the finish line. I experienced this in litigation. A lot of clients come in saying, I want to prosecute this to the fullest extent of the law. And my internal reaction is, no, you don't. And a good example of that, coming right out of a very bad scope of work, is the 6 weeks I spent one summer in Milwaukee arbitrating a case because of a lousy scope of work, and the 1.5 years it took to prepare that case involving most of the company's management. That's a big hunk out of a busy business. So you really need to be aware of what you're doing and understand it fully. I mentioned the point person or a team. Your responsibility, if the consultant has laid out the necessary conditions they need, is to provide them. And again, timely responses to requests for information. So now we're going to move on to measurable. And we're back to our example. It now includes the description of personas. And I'm going to ask you to tell me what you think my favorite word in this scope is. Unmute yourself and yell it out.
5.
Thank you. Thank you. It is 5. Thank you, Justin. I may not know what a customer persona is. I may not know what market need is, but I sure do know what 5 is. So when I'm spotting, reviewing, that's the kind of thing I'm looking for, is actual quantifiable deliverables. The other thing I think, and Emily Braley told me this, that a technical scope of work had come across her desk. I think it might have involved developing a fire protection system, something like that. And all that was in the description of the deliverable was details. That was it, one word, etc. That was not good. But in a business like that, you have so many external standards to point to as to what your product is going to look like. So where you've got them, they really are almost the ultimate, well, except for 5, objective criterion for determining whether work has been done or not. It's up or down, it complies or it doesn't. So look to industry codes, legal code, by which I mean regulations or statutes or something of that manner. And if you're going to be testing, what constitutes an acceptable test result? There's a really interesting kind of linguistic difference between MTI and a lawyer. When I think of a deliverable, I think of something tangible, physical document. And I distinguish that from a milestone or a performance because it may not generate a piece of paper. It may just be the completion. So in our example, identify 5 target personas and conduct in-person interviews might be performances, but they don't necessarily generate a piece of paper, although they might. And then the deliverable would be the written report. And Emily when she reviewed this, was disturbed by that. So a drafting tip, if you're working on a Merck scope of work, if I knew it was a Merck project, I might add something like this. I can't actually see the top of my screen, but how much difficulty is it? How difficult is it to actually list the target personas, what they look like, and have the client sign off on them? You'd probably do something like that anyway. And then there's file documentation. Similar adjustment would be an approval process for approving the interview questions. And then you'd move on to your written report. So, think of approvals and review and editing as a tool for kind of demonstrating that the work was done. Now we're going to move on to achievable. And this, I would say, you really, as a consultant particularly, need to under-promise and over-deliver. And this is an exercise in humility, okay? So many of us say, oh, you're going to get the best result ever. Don't. Not in a contract. A contract is not a sales document. You can, have promotional materials that talk about how great you are, have a client say, I got the best possible product, but it has no business being in a contract because you will be held to it. Particularly stay away from to the client's satisfaction, because as we all know, there are clients who are never satisfied. Avoid those superlatives, avoid words like certify, I've got my list here, certify, warranty, guarantee, and satisfaction, unless it's part of a request for a proposal, in which case make darn sure your lawyer reviews those provisions. They have more legal oomph than you can possibly imagine. Your job is not to do the best. Your job is to do your work as a reasonably prudent professional would do it. If you want to exceed that, that's part of your company culture, please, go ahead. We need more of you. But your lawyer should be telling you not to promise it. So, with our example, we're not promising to produce the 5 best target personas. We are promising to create target personas that will answer the questions we would like to answer reasonably well. Good enough. So now on Merck, I'm going to wrap up achievable with a note. The Merck Merck grant is only 3 months long. And so think about what a 3-month deadline really means in terms of getting something done. Emily and I talked about this, and we think that the solution may be that you need to make serial applications. Get done with one phase, fill your application in, put up for the next phase, because sometimes you don't know until you've conducted customer discovery what you're going to do next. And there's no point in drafting a scope of work that Tom is going to reject if you're going to do that. I don't think you're going to find it terribly onerous. I kind of looked at it. They're short projects anyway. You've got a $10,000 cap, may actually be $15,000 cap per company for a 2-year window. And there is a lot of funding available. So because of ARPA, the Recovery Act funding we got, there's $1 million and $500 for the next. And that's a lot of $10,000 projects. Okay, so better for you to break up your project into several applications than to hurry to get them in because you're afraid they're going to run out of money. I don't think they will. Can't guarantee it. See how I did that? All right. So now relevant, Tom really did a pretty good job here. What you're looking to do is match the objective of the project to the deliverables. And I would hope that any consultant who drafted a scope of work had the objective in mind. So I'm not going to say too much more about that. But when it comes to your contract, I bet everybody wonders, who's not a lawyer, why every contract begins with a whereas clause. Okay, the whereas clauses are setting the context. It's, whereas, I'm me and you're you, and whereas I want to have a marketing plan and you develop marketing plans, we've agreed to do the customer discovery for a marketing plan as follows. That's what they are. And I'll give you a hint. You don't have to use the word whereas. I did an Ask ACE column maybe a year ago, I'd say, on scopes of work, but I gave people permission not to use legal terms. What always baffles me on particularly client drafted product is, everybody hates legalese, but everybody tries to sound like us. It's really not necessary. English will serve. And then finally, time bound, deadlines and schedules. If there is a firm deadline, state it. We really need to get this done by such and such. Francis, to your question, sometimes you really can't, take the time to do a really detailed schedule until you know you've got the money. So I will sometimes put a do your best schedule in, anticipated phases and completion dates, something like that, and then require a sit down at the beginning to flesh out the details once you know you're funded. So that would be an anticipated completion date. There are firm completion dates, and then there is a nuclear deadline, which is time is of the essence, is that if you don't do this, I don't pay you. Okay. I only see these in real estate contracts. But if it's in a contract that you review, really ask whether it's necessary or whether you're just going to assume that everybody's going to get along and muddle through. So then, Francis, this is the kind of language I would add to a scope of work. And specifically, the last sentence of that is important, is the idea of a regular meeting where you look at where you are and make your adjustments and then document what those adjustments are going to be. Okay, so I'm done with that portion of the program. Are there any questions? Okay. Oh, we've got some in the chat, maybe. Yes, Jamie, that is, in fact, the cap on the MTI funding. It's a $20,000 project. So any other questions? Okay. Well, thank you very much. Let's take a little bit of a break, and I'll come back in about 3 minutes. So let's continue on. I know I threw a lot at you, and to save you from having to take notes, what you'll find when we get to the exercise in the workshop is you actually have a list of the tools that I have in my toolbox. And I hope that between that and the slides and your memory, you'll be able to use the tools when you draft your next scope of work or evaluate one. We're going to start with the legal framework, which is much shorter, because I wanted to focus on just the key terms that you need to really have in mind once you've finished your scope of work, and make sure that they match. That is all important. What we're going to cover here is a very important clause that, it's going to be in the contract. Any standard form contract is going to have an entire agreement clause, but I think it's good to point out why it's a significant clause and you should always have in the back of your mind. But the real guts of what I think you need to pay attention to are termination and changes in the scope of work or extra work. And by changes, I mean things like delay and changed conditions. And then finally, I'm going to touch on dispute resolution. I will say up front, I'm an advocate for it. Your own attorney may have a different view, but I have some reasons why in a contract of this kind, I think it's worth considering. And outside of the scope or more particular, kind of job by job things you'll find in a contract. If you are if you're a grant writer, that's not a good example, but if you draft content, you're going to need to deal with copyright issues, but that's beyond the scope of what I want to do here. So we'll make that go away. The entire agreement clause, if you've read any contracts, you've come across it. And sometimes it looks a little bit baffling, so I'm going to highlight it for you so that you can see where the guts of it are. So what it says basically is that the four corners of this document are it. All right, that's it. If we talked about other things and it didn't, add other pieces of the work and it didn't make it into this document, it's not here. It just is not here. It's not my obligation. That helps a lot if there is a dispute and people are, arguing about who said what when. You can point to the agreement and say, no, this was what we finally agreed on. It's another good reason not to include those superlatives in your agreement. Leave them for your marketing materials. And don't promise more than you are sure you can deliver. And here's what you need to understand of. It's this. Okay, so basically, when it's written, it's done. This is another reason to get everything in the same document. I have, in fact, pieced together contracts from jottings on cocktail napkins, and it was not fun. So you really want to gather it. It's kind of like housekeeping. You want to kind of gather it in one place. So just looking at my notes here. All right, so I'm jammed again. Okay. So let's talk about termination and changes as the two most important processes that you really are going to need to think about. As I said earlier, the legal terms are an opportunity to agree on what will happen when something goes wrong. And it's hard to evaluate that if you don't know what's right looks like, which is why you need a good scope of work. And basically what you have is two options when you're not getting along, which is to end the project and go away mad or amend the terms. So your focus here needs to be on both process and payment. So the process that acknowledges the changes to the work and the payment that will accompany that, either up or down. So there are two flavors of termination. One is for cause and one is for convenience. For cause, I left out one of the important for cause elements, which is insolvency. If you have a client who is clearly insolvent, you do not, if you've got an appropriate termination clause, have an obligation to proceed if you know for sure you're not going to be paid. But the key words there are for sure. So you can terminate for non-payment, non-performance, and non-cooperation. The usual process for termination for cause is notice and a cure. So you let the other party know that they haven't paid you, or that they haven't gotten the information that you have requested 5 times, or they've simply disappeared. You know, where are you? Where's my project manager? The usual process is to write something polite and say, you know, pursuant to the contract, we've got a problem here, and you have 10 days to correct it. And then if the 10 days are not met, then you have the option of terminating. It works both ways, by the way. You know, get back on the job would be something that you might, if you're a client, have to tell your consultant, but of course, none of the consultants in this room. For convenience is, I used to have ambiguous feelings about for convenience clauses and who would be entitled to exercise it. Overall, over the years, you know, watching projects go south, I think they have a place. And the usual process is notice. And what it means is, I can't go on. I cannot go on with this project. Something has happened and I need to terminate it. In which case the process is notice. There's usually a longer period before the contract actually ends. And so you need to, you know, establish what that is. Then we come to what your obligations on termination are. And sometimes they can be exactly the same. And this is I pulled this out of a fairly standard contract I have, you know, in my files. And I thought, yeah, you know, this doesn't look too bad. So I guess I'll use it. Then I started reading it in detail. And I remembered what our example was, which is of a phased contract. And if anybody wants to be brave and spot the gaping hole, there are actually 2. Okay, I'll help you out. What if the project stops mid-phase? How are you going to figure out how much the consultant gets paid? Okay. The other gaping hole. What if the consultant is fired, but the project needs to go on and the client needs to hire somebody else to finish the work and it costs more? The consultant is in breach. I mean, if they've been fired, they're in breach. So how does this help? How do you know what the consultant is due? Does the consultant get to keep what it's been paid to date? Okay. So when you plug the holes, if a project ends mid-phase, you're going to need some way to compensate a consultant for the work performed but not completed. Okay, this standard form agreement does not comprehend that because it isn't built to deal with a phased contract. In that sense, it was not safe to sign. There are all sorts of ways to get around this. You can say, you know, between phases, we'll keep track of the hours and you'll pay such and such an hourly rate. And these are the hourly rate, and each member of my team has a different hourly rate, so you spell that out. You can do hourly with a cap so that the hourly money, the hours spent at the hourly rate do not exceed the amount of the next progress payment. That's one way to do it. A kill fee, which allows you as a consultant potentially to actually make a profit on the job, because profit tends to be loaded towards the end of any job, or some combination. But you have to really think through what the appropriate tech tool is to address that situation. Now, if the consultant is fired for cause, the client should be able to set off the additional cost of completion. So it's the value of the work performed minus the cost of the replacement contract minus the cost of the original contract. Okay, that would be what the consultant has earned, but it certainly is not spelled out that that is the formula you're going to use. Okay. Changes in scope. Preaching to the choir, I hope by this time, specificity, time-bound, and achievable. You cannot determine whether the scope has changed unless you know enough about the scope to begin with. And changes in scope can include extra work, which means if you've carefully done your scope and you've carefully done your exclusions, it should pop out at you when the client wants you to do more. And what usually happens in these situations is that the consultant prepares an amendment to the contract, which is like a mini contract, because it has to have a new scope following all of the SMART principles, sometimes referred to as a change order if you're particularly in the construction trades, and then a proposed price, which can be anything. As you do this, though, you need to really figure out what you need to do to amend the schedule. It might not be anything to accommodate the fact that you're performing the extra work. Now, as to delay, it really is, you really have to be upfront. You know, nobody can just kind of turn their head and say, oh, this isn't going well. Somebody actually needs to stand up and say, we're behind. That's why regular progress meetings are important. So you need to determine the cause and the impact on the schedule, and you may have to have the uncomfortable discussion about who is responsible and therefore who might have to absorb the cost of the delay. But then you get to a really tricky question, is how do you figure out the cost of a delay? I mean, really, if a job is really, really screwed up, how do you get your arms around that? If you can agree on a schedule extension and price adjustment, you prepare an amendment. If you've got one of those really woolly projects, you may want to consider liquidated damages, which means if a project is delayed, the consultant will forfeit $10,000. And that's not, it's a no-no to call it a penalty, even though effectively that's what it is. But you have to, it requires you to set that price at the beginning. And it does at least let you move on. The alternative to that, which is kinder and gentler, is an early completion bonus. So if you get this done ahead of time, we'll pay you more. You know, so that's another way of dealing with it, because it provides the incentive to work for the additional dollars. Some of the stuff is absolutely not in the consultant's control. So now, changed conditions. If it's obviously you want to go through that same notice. I didn't plan on working under these conditions. If it's a client responsibility, honestly, you're going to have to treat it as a breach. So you then move into notice and an opportunity to cure, And when you're drafting, you need to make sure you have a cure period you can deal with. Do these questions, if you're on a 1-week job, it might be a matter of hours. If it's a 4-month job, okay, maybe 10 days, you can live with 10 days and it really won't affect the outcome. Or you say, okay, if you can cure it in 10 days, we'll just tack those 10 days onto the completion date and move forward. If the condition can't be cured, you do have the option of negotiating a price for working under the changed conditions. And you also have the option of terminating and collecting what you are owed under the termination clause. Finally, I'm going to talk about dispute resolution. The usual, because what this means is you've drafted a scope of work, something has gone wrong, you've moved into you've had to look at the legal terms, which you hope you'd never have to look at. And you're in a position where you are in a genuine bona fide dispute. So as I say, I really do like to have an arbitration clause. You can agree to waive it, but what it does is create a private forum in which to resolve disputes. The usual argument is timing. Is usually it would save time and money. And for smaller projects, this is probably true. Larger projects, not so much. Just remember my 6 weeks in Milwaukee and how much time and money it took to resolve that particular dispute. And I think, honestly, we may have saved some time, but I really doubt that we saved any money approaching it that way. But as I say, the additional benefit is privacy. Both parties may not want to hang out their dirty laundry in public as to what went wrong on this job. So arbitration is entirely private. There's generally not even a record. There might be. In Milwaukee, we opted to have one because it was so lengthy. And the award comes out as a number and who it's to be paid for. So there's none of that, you just agree that whatever the arbitrator is going to decide is what you're going to live with. Now, the disadvantage of arbitration is that you're probably going to get a compromise result. Arbitrators, in my experience, tend to split the baby, maybe not award the full amount to whoever is claiming it. And kind of tries to figure out, what the amount that it should have settled at would have been, which is usually a figure that both parties are unhappy with. And the other thing you lose is the right to appeal. And that is a significant consideration, but it's more significant when it comes to the legal terms than it is to the scope of work. So I just plant that bug in your ear. So my final comment is that, let's see, I have it written, is that your chances of a dispute go way, way down if you've got a good scope of work and is clear, but you can't always predict the unpredictable. You may not need to use the legal terms at all, but they do provide a roadmap for getting you out of a tight spot. And so they're worth paying attention to. They just have to match the job. And if you have those two in combination, a detailed scope of work and a well-coordinated set of legal terms, you have a very good chance of resolving the dispute on yourselves, among yourselves, and having a successful project. So again, my question mark. Does anybody have any questions?
I do.
Okay, hi,
Hi there. When you were talking a couple slides back about potentially like looking at the value of what was done versus subtracting, getting somebody new to do it, that whole thing.
Gaping hole number 1 or gaping hole number 2?
This one. There we
Okay.
go. Cost of replacement contract. Like, are you, I mean, that's something I was unclear if you're saying that should be in a legal contract, or you're saying this is something that might arise when the contract.
It might arise. I like to at least make reference. I mean, it's basically called benefit of the bargain damages. And it is the usual legal rule, but if you look back at that, it's very vague as to what the contractor is due if it is owed if they're off the job. And the only thing you would have under these circumstances is phases and payment. The consultant who breached might be perfectly happy to walk away with what he's already got in his pocket.
Uh-huh.
So you need to say something about the owner has rights as well. And there are contracts that actually spell it out. And that's how they spell it out. The value of the work performed, which in this case would probably be the phase that they got paid for, phases they got paid for. Then you take the cost of the replacement contract and subtract out what the, basically, I kind of wrote this wrong, but you subtract out the remainder of the payments that would have been due to the original contractor.
Mm-hmm.
So if you want to make a note, that's called benefit of the bargain damages. But
okay. I guess what I'm confused about here is, as a consultant, I don't think I want to introduce the idea in a contract that you could replace my work with somebody else who's going to be like, potentially, like, what if they were like, well, you didn't complete it and now we found somebody else and they're 3 times as expensive, so therefore you're not going to get, I don't know. I was like, I don't even want to go here. Maybe a misunderstanding.
Up to you. But remember, it's buried in the legal terms, not the scope of work. But you know, there's some judgment to be exercised here. All I'm pointing out is that it is a whole.
Okay. Okay.
Right? This is a probable legal result, but as that language stands, it's ambiguous.
Okay, that's what you're saying. You're not necessarily saying to put this in. You're just saying
I
that
have-
this is a potential downside that could happen. Okay, got it.
I have seen it.
Yeah.
I can't remember off the top of my head whether I have seen it in the consultant drafted terms of work. It's something you would probably encounter if you're dealing with a big company that already has its vendor contracts nailed down, right?
Right.
So that's, this would definitely be more favorable to the client to get it spelled out.
I think that's what I'm feeling.
Yeah, but you know, it's what you might be confronted with anyway. And you know, if somebody comes back to you and says, I want this in it, you're going to be kind of hard pressed not to agree with it. But you don't have to offer it, I suppose.
Right. Okay. Yeah, got it. Thank you.
Anne?
Yeah.
Tova has her hand raised.
Yeah.
Oh,
Yeah.
okay. Who was first? Tova?
Go ahead, Tova.
I have no idea who was first.
Please
thank
go
you.
ahead. I'm happy to be second.
So the same question Emily had, the same sentence, the one you had in red. When I read that, it seems fine to me, Carrie, which is probably why I'm not a lawyer. It seems to me when I read that I'll get paid for everything I've done.
Okay.
That I'll
well,
get paid for everything I've done, right? Customer shall pay service provider for services rendered. Did I miss something?
you did.
Sorry.
This is what you missed. Okay. So you've got a phase contract. You've identified 5 target customers, and you start drafting the interview questions.
Yes.
Okay.
Oh, it's because, but if you put in like $1 per hour rate or something, so if you're
But you
partway, then you got yourself covered too, right?
Right. So you need to
Okay,
deal with
I
that.
often do something like that.
Yeah, you need to deal with that. The problem is with that paragraph I gave you, which was
Yeah,
standalone,
I get it.
There was
It's not
nothing
clear.
else.
Yeah, okay, I got it.
it wasn't just unclear, it had a big gaping hole.
It did. It
Yeah.
did. I get it.
So-
I get it. Okay, thank you.
So, Anne,
Yes, I do. By the way, I'm delighted to have discovered your group, and I'm really pleased to begin learning what I am able to with this session and others in the future. I look forward to. My work is in international development, and I'm reminded of a project I was working on in which I was a subcontractor to a U.S. university, which was on contract with an international multinational corporation who was on contract with 9 entities of a foreign government.
mhm,
And there was a breach of the contract that affected me. I was developing I'm a linguist, and I developed language training for the labor force. So I was developing an elastomer English curriculum to train science high school graduates to become elastomer technicians to manufacture tires.
mhm.
There was no elastomer English program for this country where everyone spoke a foreign language, a language that was not English. We had contracted that the teachers would use our customized curriculum. The teachers who were not hired by me, but were part of an institution that was brought in as a secondary step to a solution, and it was a complicated project. They refused to use the curriculum that they had agreed to use in the contract.
They're in breach.
Yeah, that didn't make any difference. The project went ahead. There was absolutely no recourse from me to the university, to the multinational corporation, to the 9 entities, including a royal prince at the top. It was amazing.
Yeah,
Their laws didn't apply to our laws, apparently. And
right,
there was
right.
a difference in the legislative terminology in these multi-layers,
Yeah.
which it never occurred to me that I should check all the layers of the legislation, of the legal terms,
Yeah,
all the entities that were involved.
it's a problem. I
Yeah.
just had to hire Dutch counsel for a client on a contract dispute
Yeah.
that was performed in Amsterdam.
Mhm. Mhm.
So I just handed the client over to them
Yeah.
for it, and the client had not really had a contract. It was all done on a purchase order. So we weren't dealing with any legal terms at all to get ourselves out of this problem.
Yeah. My issue was that I was the only woman on the project in a country where women are usually not accepted as professional.
Right,
So I was under an extreme cultural pressure to not rock the boat
right,
and to
Right.
be, my statement to myself, dressed as I was, everything perfect to their expectation, was they're only going to remember how professional I am. I will not stand up and scream at all the
yeah.
things that bother me, but it was problematic that I would raise the issue. Excuse me, your teachers are out of they're not abiding with this contract to use our curriculum. They're using their own. The only thing, practically speaking, that actually made the needle move was that when we used our tests on our curriculum that was supposed to be taught,
They did better.
almost everyone failed because they were being taught
Ah.
by teachers who were not using our
Using the-
curriculum and were using something that they were
Right.
familiar with that was totally unrelated to elastomer technology.
Oh, I
Yeah.
thought you had a control group that you tested. Yeah,
No.
No.
So
yeah,
their students were enrolled. I required a diagnostic test to know where they came in with their English. Nobody would give the test. It was just rife with
Well,
violations.
my question as an American lawyer, though, is did you get paid?
I did get paid. But
Should you have gotten paid more for combat pay?
I negotiated that in as well.
Yeah,
At the time that I was out there. I also negotiated a political action insurance.
Yeah.
Because I was accosted by the fashion police.
Mhm.
anyway, it was,
Yeah. Sounds like a nightmare, but this
it was
yeah,
a
you
very
did-
educational contract.
yes.
But what ended up happening was that people paid attention, the administration paid attention when all the students in that course that was taught by the teachers teaching their own curricula, not ours, when they failed. Because then that made their project look bad.
Right. Right.
So there was a natural consequence that ended up making people pay attention.
Yeah.
It wasn't the contract that made them pay attention.
Right. Right. I mean, what can I say? Yeah. But that is an objective standard, passing the test.
That people follow the terms of a contract, no matter what country.
No. I'm saying when we talked about external standards, you can put in testing and desired result.
Yeah.
You know, as a measure of whether the other side is performing.